Greater Houston and the Southwest Rockies region of NAA. We want to thank you all for coming. We particularly want to thank National LERA, the Executive Director, Emily Smith, and Bernadette Hyman, who is the Membership and Marketing Coordinator, for helping us and getting this organized and hosting it and running it. And then, of course, I want to thank moderator and friend Pilar Vale, who is going to run this, as well as our speaker Rick Bales, and members of panel members John Harper and Mycah Vaughn. We've got, thanks to Moretta, the course was approved for 1.25 hours of MCLE credit by the State Bar of Texas. So we'll put that course number in the chat so that anyone can go ahead and submit their attendance. If you have questions, go ahead and submit them in the chat, and Pilar and I are going to keep an eye on them. But try to make sure we see that it's an actual question, not just discussion among attendees, so that we know you want it presented as a question. So I want to go ahead and introduce Pilar now. She is an attorney arbitrator and an NAA member. She's currently the vice chair of the Southwest Rockies region and serves on numerous committees at the national level. So Pilar, I'm going to go ahead and let you introduce the speaker and commentators and let you take over now.
All right. Thank you, Sherry. So our featured presenter today is Rick Bales. He's both a professor and an arbitrator. He's a member of the faculty at the Ohio Northern University Law School, where he teaches a wide variety of labor employment ADR classes, as well as torts and civil procedure, every lawyer's favorites. He's published more than 80 scholarly articles in his capacity as a professor. He's also authored or co-authored about 8 books. Most of his work deals with ADR, labor and employment, and most recently his scholarships focused on COVID-related issues in particular. Rick is, as I said, a labor arbitrator as well. He serves on panels for FMCS, AAA, and the SERB. And he's a proud member of the National Academy and also a proud member of the College of Labor and Employment Lawyers. Perhaps most interesting, most fascinating about Rick, in 2010, he served as a Fulbright specialist, providing dispute resolution training to labor judges in Malaysia. And then 3 years later, he got to do it again for Indonesia. And as a result of his time as a Fulbright scholarship, he became involved with the Cambodian Arbitration Council, a model for labor arbitration designed throughout Southeast Asia. And he also got a chance to work with garment workers in Myanmar. And it sounded like that's pretty exciting stuff. But unfortunately, it sounds like the project was disrupted by a military coup in 2021. Another reminder that our work intersects all areas of life and local and national and international politics sometimes. For commentators, we're going to have 2 very well-respected attorneys. Mycah Vaughn is a labor attorney who graduated from the University of Houston Law Center in 2014. Since then, she's been counsel for Teamsters Local number 988, which is the largest in Texas with just over 7,000 members. Ms. Vaughn oversees the representation of bargaining units from companies as diverse as UPS, Kroger's, Cisco, First Transit, Hertz, and many more. She currently sits on the board for LERA, the Houston chapter, and she's also a trustee for the Houston Area Pension Fund. As legal counsel for Teamsters Local Union 988, Ms. Vaughn is responsible for overseeing negotiations, grievance handling, arbitrations, and NLRB charges. She's also dedicated to advising the executive board and staff in various areas to ensure organizational compliance with the myriad of laws. And then as our second commentator, we're going to have Mr. John Harper. He's a labor attorney who graduated from the Southern Methodist School of Law, cum laude, in 2001. Mr. Harper's with the Littler firm in Houston. He represents employers at all aspects of labor relations and employment law, including organizing drives, collective bargaining, interpretation and application of the labor agreements, grievance and arbitration handling, and also matters arising under state and federal anti-discrimination, anti-retaliation, and wage and hour laws, and matters arising from everybody's favorite, ERISA, the Employment Retirement Income Security Act. John's previously been named Best Lawyer in America from 2018 to 2022, and he was named a Rising Star in Texas by Super Lawyers between the years of 2007 and 2014. And he's published numerous articles and blog posts. I think an almost complete list, it looks like, may be available on the Littler website. So I welcome you all. The format generally is going to be that Rick is going to speak for a bit on a particular subject, and then he's going to turn to the commentators for comments and questions. We want it to be an interactive session. So like Sherry said, just put your questions in chat, but mark them as such so that me and Sherry can identify them. And with that, I turn it over to Mr. Rick Bales, professor and arbitrator extraordinaire.
Thank you so much, Pilar. I really appreciate it. And I appreciate the opportunity to be here. Thank you all for putting the program together and for inviting me to participate. Like Pilar said, this will be an interactive presentation, and it really will be less of me as a talking head with a couple of commentators, and it'll be more, I think, the three of us kind of doing this all together. And we strongly encourage members of the audience to add, especially if you've had experience with one of the topics, please jump in and let us know what your experience has been. I think the goal of this presentation is for us all to share our collective wisdom and collective experience with a topic that caught us all by surprise a couple of years ago and has required us to be on our toes ever since. So hold on. Almost all of my presentation will be focusing on arbitration awards that arise out of COVID-related issues. So if COVID has created some sort of a novel situation in the unionized workplace, what have unions grieved and what has gone to arbitration? Roughly half of the cases that kind of give rise to what I will be presenting on are from Canada. And it's not necessarily because there are more Canadian awards on COVID than there are in the US, but Canada has a much better system of reporting arbitration awards than the US. In Canada, all arbitration awards are public, they are filed, they are collected in a centralized database, and they're accessible for free by anyone who wants it, which is golden to me as a researcher. And so anyway, so a decent number of the cases here are Canadian. As it happens, Canada and the US both have very similar labor statutes, a very similar system of arbitration, of labor arbitration, and at least in my experience, the Canadian cases pretty much mirror what would be happening in the US also. So this presentation will really go in two parts. Part one is what I will call the first wave of COVID cases, and many of these arose during the first year or so of the pandemic. And then the second part will focus more on issues related to vaccine mandates. Now, even with part one, I don't know, in some ways it's kind of hard for me to put myself back in the situation where we were when COVID first came out, when we didn't know what caused it. We were all really, really washing our hands and disinfecting everything that we could see. But nonetheless, even though that part of COVID seems hopefully in the distant rearview mirror, it nonetheless still affects a lot of what we do in grievance resolution, but also in bargaining. And so when we're talking about, I guess what I call part one and the first wave of COVID cases, our focus, and I think this will especially be true with the comments of Mycah and John, but our focus will be on, okay, so how does that affect us now? And then the second part of this presentation will focus on the vaccine mandate cases. My understanding is that a lot of those are just now hitting the grievance process, and we'll spend a fair amount of time doing that. So that's where we're going. Part one is kind of the first wave of COVID cases. What can we learn from those? And part two will be vaccine mandates. So with part one, and what I call the first wave, pay issues like sick pay for quarantine, layoffs and furloughs, especially when COVID first hit. A lot of workplaces were hit really, really hard. The restaurant, entertainment industries, for example, airlines, and a lot of folks got laid off. A lot of those layoffs got grieved. Cuts to employee benefits, COVID workplace policies, most obviously, right? Everyone has to wear masks. Everyone has to perhaps submit to a COVID test or a nasal swab. Safety issues at the workplace. Is the employer providing enough PPE? Or perhaps maybe the employer is requiring safety procedures that I don't like, or I find offensive, or that I find violate my medical privacy. And then mandatory returns to work. So this will be a kind of a game plan of what I would call the first wave of COVID-related issues. And the first topic I want to open up is the idea of premium pay. So many collective bargaining agreements contain premium pay provisions. Most of them were drafted with the idea of up in my part of the world in Ohio, a snowstorm, or in Houston, a hurricane, or a flood, or something that lasts for maybe a day, a couple of days, a week. And what happens then? Often workplaces close, but someone still has to go out and work on the roads, make sure that the lights are still on, make sure that the hospitals are still functioning properly. And many collective bargaining agreements had provisions in them, or have provisions in them, that call for workers who are working when most employees are not working to get time and a half, overtime, some sort of premium pay. With COVID, the big challenge is that COVID didn't quite fit the model of a hurricane or a snowstorm or some other weather-related emergency. COVID obviously lasted much longer. For much of the time, the duration was completely indefinite. We had no idea when we were all going back to work or when we would go back to work as normal. And when we did go back to work, we kind of went back in bits and pieces rather than all at once, from lockdown to back at work as usual. Often people went in waves. And so how do those premium pay provisions fit in a situation like that? And not surprisingly, a lot turned, the cases really turned on how the language in the collective bargaining agreement was drafted. But for the most part, when arbitrators would analogize the situation to the weather-related events for which most of these provisions were drafted, and so usually, if most of the workplace was closed and a handful of people were working, if the contract language supported it, then the arbitrators would tend to find that the folks who were working were entitled to premium pay. Now, one of the things, even though hopefully this issue is in our rearview mirror, nothing can have an effect on bargaining, on moving forward. And so I wanted to turn the give the table now to our commentators to kind of talk about, okay, so what are the lingering effects of the issues that arose regarding premium pay?
Well, and I'll go ahead and comment. Interestingly enough, the majority of the collective bargaining agreements for which we represent the bargaining units within our local do not contain any type of disaster or premium pay language that you had mentioned earlier. Very few of them did. And for the ones that did have some sort of language or clause in there, it was more so to the benefit of the employer, by which it only was invoked if the employer declared it a disaster. So that has been problematic for us. But again, like you said, being in the unique place of Houston, this is not the first time we've had to look at pay when operations were closed. I mean, we most recently before COVID had the freeze, or that was right after COVID, I'm sorry, and then Hurricane Harvey. So we have been in these positions before where we have to have those discussions with employers. But yes, certainly premium pay became a huge issue moving forward from this. I'll just say that some of the industries that we represent include grocery and liquor distribution. And so if you think about the first couple of months of the pandemic, there was high demand in those industries. So premium pay was something that was necessary, and that all employers in that area were willing, surprisingly, to have those discussions, and some of them even initiated those discussions with the union. Most of them led to side letters in which we defined a duration of time that the premium pay would last, of course. And the difficulty there is when some of those agreements backed into contract negotiations, it just brought a different beast into the room or at the table, because now, you know, employees have gotten a taste of that hazard pay, of that premium pay. They know that, you know, for at least a year, for some of them, the employer has been paying $2 extra per hour. So now that they see that, oh, well, you guys can afford that, you can do it, it kind of upped the stakes for the employer in negotiations. And then certainly to your earlier comment regarding some type of disaster pay, yes, this, you know, was an eye opener, not just for the contracts for which we develop proposals, but as well as the membership actually submitting proposals. We saw a lot of proposals for some type of hazard or disaster pay, or some type of act of God language. Most of our contracts have that, but the ones that do it typically is to the benefit of the employer by, you know, relieving them of the obligation to pay a guarantee. So now employees are demanding that. So yeah, it definitely raised some issues that, you know, we had to have discussions with multiple companies and look at what language would look like for disaster premium pay. Absolutely.
And I would largely agree with Mycah on her comments in terms of what I saw from my clients. You know, when this first hit, clients were really trying to figure out, do we need to shut down? Do we need to have people in? How do we get people to come in? How many people do we need to come in? How do we incentivize them to come in, and that sort of thing. And so like Mycah, most of my clients' collective bargaining agreements do not have hazard pay, and many of them don't have act of God clauses. And so not only that, but they're also faced with, you know, some unionized facilities in some places and non-union facilities in other places, and trying to adopt a uniform approach to these sorts of issues across a national platform. And so, you know, a lot of my clients did move in the premium pay or hazard pay direction, just simply to incentivize people to come into work during a very uncertain time. In the situations where my clients did have union relationships, for the most part, we did work collaboratively with the union and approach the union on trying to negotiate, or, you know, at least advise the union that we were moving in that direction. And, you know, frequently the unions didn't, of course, object to the extra pay. Where my clients really started running into trouble, you know, frankly, both union and non-union, was how do we end this? You know, when we first started COVID, it was, you know, this is going to be a couple of months, or this is going to be, you know, maybe 3 months, maybe a quarter. And then it was 6 months, and then it was 9 months. And pretty soon what was hazardous operations looks like normal operations. And we've got to move back to a more sustainable wage model. And so starting to, you know, unwind that sort of program really proved to be a labor relations challenge. And Mycah mentioned that in terms of the, you know, the expectations that her clients had with respect to collective bargaining, and the same was true on the non-union side. You know, once you create an expectation of hazard pay in a certain situation, it becomes a tricky situation to unwind it. And really, what I found is, you know, transparency and advance notice and explanation of what was going to happen and when it was going to happen and why it was going to happen, you know, really went a long way to try and if not make employees like the transition, to at least understand and expect and be able to plan for the transition.
And if I may add, I think the media was very helpful during this period, because everyone was focused on the news, with everything changing so often. And so we saw all these stories. Well, this company's paying their employees this type of premium pay, and it was put out there more. So it caused some employers and employees, of course, to start to ask, well, why isn't that something that we're receiving? And it put the pressure on them to take that into consideration. For some of the employers that were a little late in offering some type of premium pay, we were successful in some areas. And by the time they were willing to have those discussions, applying it retroactively from the period of when the pandemic began, which was great. And others that refused to pay premium pay, we proposed some type of hazard bonus or premium bonus or frontline worker, essential worker bonus to be applied during contract negotiations. So that was something that they brought to the table. We risked our health for the last year, and you guys did not afford us any additional pay. And some companies actually did put that forward in the new negotiated agreement. So that was nice.
Yeah, and I just saw a comment come in about certain frontline workers, grocery workers, and restaurant workers, and healthcare workers, and facing particularly hostile customers. Facing a lot of anger in terms of just the public, airline workers, once we were able to fly again, kind of the same issue. And that raised another point that I wanted to discuss on this, which is a lot of this, in my client's experience, depended on the type of industry and the type of interactions that employees were going to have, not only with one another, but with the public and others. And so, we really discovered there was a big difference in my clients where if you're mainly office workers and you can work remotely and accomplish your work that way, that was a much less compelling case for some form of hazard pay or premium pay than if you're, a restaurant worker, or especially like in the grocery industry, where you're really, coming in every day and putting yourself at risk of exposure and putting yourself in front of folks who may be a little bit angry with what's going on.
Said John.
Just
So
thinking,
another issue. Oh, go ahead.
for you guys, do y'all foresee a press and negotiations for more systematized hazard pay in the future, based on our experience with COVID, but also the suggestions that disease is going to be a prevalent problem in the future? What are y'all seeing with your clients and their interest in negotiating for a longer period of time for the future?
And I'll take that one first. That's not something that I'm seeing either my clients really having discussions or making proposals about at the bargaining table. And honestly, I'm not seeing a lot of proposals coming from unions on that front either. And so, I've negotiated probably 7 or 8 contracts this year, and I don't think I've had a proposal in a single one of them for, institutionalized hazard pay or something like that. I think and one thing that maybe COVID taught all of us, and I don't want to speak for Mycah on this, but it was so unpredictable and changed so much that this is, for me, almost we'll cross that bridge when we come to it again, because we don't know what the next one's going to look like.
True. Mycah,
And
what was your...
on my end, yes, I have been seeing that be proposed from bargaining unit members. However, the difficulty we have is if we're going to put some language into a collective bargaining agreement that addresses the pandemic, how do we define when it would apply? Because there may be situations where, okay, it's not necessarily a pandemic, but something else that requires, government shutdowns, and we would certainly want that to fit in the box. Also, like I said, with Houston, weather, anything like that. It's just so hard for us to define events which would invoke some type of generalized hazard premium pay. So I can't answer yes, we've seen that proposed, but when we have attempted discussions with employers at the table, that's sort of where it goes. And as well as, the intention to just handle things on a case-by-case basis, because everything might be a unique situation of its own.
Mhm. Thank you.
So another topic that came up in a handful of arbitration awards, although not nearly as many as I expected, was issues over returns to work. So remember when COVID first hit, everything shut down. And then kind of slowly we started coming back to work and back into a regular workplace. And I expected that there would be a lot of grievances from employees who were unable to or were afraid to come back to work. And I didn't see very many of those. There were a handful, but not very many. There were far more arbitration awards on the issue of schedule changes and hour reductions. So reductions in hours, typically by the types of industries that were hurt most by early COVID. So the restaurant industry, food distribution industry, especially to restaurants, entertainment industries. If folks weren't laid off, then often their hours were cut. Often people had their hours changed radically. And so, especially again, when COVID hits hard, we don't know exactly how it's transmitted. A lot of employers moved a lot of people to the night shift to try to space people out. And have maybe everyone still working, but coming in at very different hours so that people could stay more distanced. And that gave rise to quite a few grievances. And a lot of them, had to do with, or many of these cases really, again, turned on the contract language. A lot would depend on whether, for example, the contract had requirements or guarantees, that you'll work 40 hours a week, or you'll work 40 hours a week, but no more than 4 days per week, or something like that. Again, everything really kind of turns on contract language. John, Mycah, any thoughts on this topic?
And since Mycah went first last time, I'll go first this time. Absolutely. I had clients that were looking at schedule changes and hours reductions, and and they were having to move very quickly because we went from full employment before mid-March 2020 with everybody working to things basically shutting down within a week. And so it really put my clients and virtually all businesses in a very difficult situation about how to react to something like that, especially when you have contractual obligations in place. And so, the beginning point for anything along these lines is definitely a collective bargaining agreement if you have one in place. But then you have a whole series from my client's point of view of really practical issues about, the collective bargaining agreement says X, but we can't do X. And we've got to do Y, and we've got to do it very quickly. And in some cases, the safety of our employees is at stake, and in some cases, the continued viability of the business is at stake. And so, of course, I would advise clients that if you've got collective bargaining language in place, that's a contract, and we need, to the extent we can, comply with that language. If we can't comply with that language, the next step is to reach out to the union and see what we can, at least give the union notice about here's what's going on, here's what we need to do, and see if we can get some quick input. And I don't want to, again, speak for Mycah, and she may speak to this, but Mycah, even at the top of this program, indicated how many employers her union represents. I'm sure she was getting calls, and her union was getting calls, multiple calls every day from all of the folks, all of the businesses that she was engaged with, asking all of these questions. And so, there really became a bit of a logjam. And frankly, we had clients that had to move, and they moved. And when everything kind of got sorted out, either the company and the union got together afterwards and worked things out, or they didn't, and then the grievances started to come. And in fact, I've got a couple of grievances that are still headed to arbitration over scheduling changes and location changes, decisions that the company made to separate employees and engage in social distancing and have those things, but that violated the agreement. And, the parties just were not able to come together and get that resolved after the fact.
And yes, you are absolutely correct. As far as the amount of calls that we started receiving and concerns from employees with various different employers within different industries. But I think that, it sparked our local into action early on because we wanted to be able to address these concerns. And we took a very offensive approach early on. I think the second or third week of March, we sent correspondence to all of our employers demanding, requesting bargaining, requesting times to meet for a discussion to see how all of this would potentially impact their industry, as well as what safety protocols they would want to put in place so that we can start that dialogue and work through it with more of a collaborative effort. So as John was saying, many employers did have to act with haste, but we made it a priority to respond equally as fast and be flexible where we could. And I think that was helpful overall. Some of the things that we were sure to negotiate in some of these reduced hour agreements was, of course, health insurance. So for both layoffs and agreements that we executed, allowing them to reduce weekly guarantees, we were able to maintain health insurance. For layoffs, we were able to extend the amount of time that they were able to use health insurance at no cost to the employee. The employer was paying the cost of the employee's premium share as well as theirs. And some other things that we discussed was recall issues. Our standard language for recall amount of time is 12 months before your seniority is severed. So that was something else that we had to discuss, not knowing how long the pandemic would last. And as far as touching on your comment earlier, Rick, as far as lingering effects in negotiations, when we went to the table for some of these contracts, we still had some employees that were out on layoff and coming up on month 10, month 11 before their seniority was going to be severed. So we had to negotiate provisions into the contract allowing for them to retain seniority should they be returned. So it was just an extended amount of time. But yes, we have two separate car rental companies that we represent the bargaining units. So they were significantly impacted by the travel ban. And, it was mass layoffs, and just being able to work through those issues with those companies quickly. I think we worked through the most significant of the issues, and we were able to retain seniority for those that were laid off that chose to return. Now we did, have quite a few that once they were furloughed or laid off, chose ultimately not to return. And, that turned into another problem of a high demand of labor in several industries. But
Rick, if I may put you on the spot here for a second in terms of having taken a look at these cases. How are you seeing that arbitrators are generally, addressing these issues, especially where you've got contract language saying one thing, the employer moved quickly to do something that was contrary to that, and there's a grievance that's generated from that. How are arbitrators taking account of the emergency situation?
So I think regardless, the arbitrator starts with the contract language. And usually, and just about any other context, the contract language is the end of it, right? If the contract says, employer, you have to do X, or you have to guarantee these hours or whatever, that's the end of it. And for some arbitrators, it still was. Other arbitrators were more persuaded by, I don't know, the emergency situation. I mean, if the employer can truly show that, hey, unless we cut hours, we're likely to go out of business. Arbitrators are a little bit more were, I think, more likely to be persuaded by that argument than they were in other non-COVID contexts. But I think across the board, start with the contract language, see what it says, and then kind of go from there. And John, I was going to kick it back to you. Mycah transitioned us already into our kind of the next topic, which is layoffs. Did you have anything you wanted to add on the topic of layoffs?
From a contract perspective, right, most, if not all contracts have something that's governing layoffs in the way that layoffs are supposed to be effectuated, and the way that recalls are supposed to be effectuated. And so, that's a little bit, it's not an easier thing to lay anybody off from an employee relations and a human capital and a human interaction standpoint. But in some ways, from a contract standpoint, because there's language that establishes how this is supposed to go, that's usually relatively more clear. My clients had less trouble with that than, the contract says we've got to have 5 people on this shift and we only need 2. Or, we're supposed to employ everybody at site A and we've got to move half of them to site B. So I didn't have as much of an issue here with my clients on the layoff front. We were just able to, move through the contract language and get that done. We had a few more issues, honestly, outside, related, but in the WARN context, where, how are we going to handle WARN, and is this the emergency exception or not, and kind of how does that play out? And some of those cases I think are still kind of playing out in the federal courts, but that was less of a contract issue for us and more of a WARN issue for us.
Mycah, any final thoughts on this topic?
Yeah, I will say this, let's see, back in 2020 and even the beginning of 2021, so for car rentals, for example, mass layoffs, but it went through several peaks and valleys. So we had times where no one was traveling, and then everyone was sick of staying at home. So as soon as, things were lightened up a little or travel bans were listed, we had a surge. And then those companies were recalling individuals quickly. And then, another wave of COVID hit. And again, then it was layoffs. So we cycled through quite a few times. And we had to get creative, because there were times where the company, they were in just need of employees to come in. So, we represent both airports for IAH and Hobby, both for Avis budget as well as Hertz. And, typically they have separate seniority lists for each airport. But we even had to talk through and find a resolution of allowing this employee that typically works on the north side of town at IAH to come down to Hobby, because none of the other employees that are being recalled want to come back, because we're just continually cycling through so quickly.
Yep, and that was actually how I was going to amend my prior statement. Is where the issues did come up, it was on the recall side. So if you have unit-wide seniority, for example, but we're only opening up one specialized area, we can't bring in the most senior guy who doesn't work in that specialized area. And so there had to be some conversations and some working through of those particular issues.
I find it very interesting that the layoff and recall, that the language, it sounds like the parties were accustomed to it. They've been using it, not in the COVID context, but it was deeply embedded in the relationship. And in contrast to the hazard pay, which some contracts have it, some don't, they all define it differently. I wonder if there's a good learning lesson for our industry. And in comparing how well we handled layoffs and recalls compared to hazard pay, just for future learning. Who knows?
I think on that one, layoffs and recalls just over the life cycle of a business are something that occur pretty regularly. I think this, laying aside catastrophic floods in Houston and catastrophic freezes in Houston and those sorts of kind of one-off events that do occur, nothing like this had ever happened before. From how are we going to kind of keep and retain and incentivize our employees to work in a situation where nobody really knew what this disease was about. All we knew that it was serious and that people were dying and that it was somehow transmitted by being close to one another. And so I don't think that on the hazard pay front, it's as ingrained in the life cycle of a business, fortunately, yet. But I'm certainly not a disease expert, but what I've read is we're probably going to be starting to see more of this over time. And as we see more of it over time, I think we'll probably start developing contract language like the layoff and recall processes have been developed over the last 70 or 80 years.
And John, that's a really nice transition point into the next kind of category of cases, which is safety protocols. There are grievances on both sides of this issue. Employers, or unions complaining that the employer was imposing too many or too few safety protocols. And so in Canada, a group of nurses complained, in this case, I think probably pretty reasonably, that the employer ought to be, and this is again in the early weeks of COVID, ought to be providing N95 masks, ought to be requiring social distancing, ought to be requiring nurses to perhaps work in, say, one wing as opposed to spread out all over a large facility to try to keep the if the virus comes into a nursing home, let's keep it from spreading to the entire nursing home. And on the flip side of that, the U.S. prison guards, this may be one of those be careful of what you ask for, argue that all prison guards ought to be furnished full PPE 24/7 while they're on shift. Sometimes people, the complaint was that there are too many safety protocols. So a group of Ontario nurses complained when the employer required once every, basically weekly nasal swab tests to make sure that COVID positive folks, nurses weren't coming into the hospital. And I think this is a nice transition to the point you made before, John, which is, you're talking about how this was a new situation that everyone had to deal with, right? As something that we hadn't seen anything quite like this before. And the question is, okay, so how can we work together? How can we talk this through in a way that at least makes it less painful for everyone, and maybe ideally turns lemons into lemonade? How can we use a really awful crisis to perhaps improve the relationship between the union and the employer? Any thoughts from either of you on safety protocols, but more generally on how we can make this positive moving forward?
Well, I'll say that as far as safety protocols, a lot of the grievances, informal as well as formal, so complaints, were that there weren't enough safety protocols. That was what we had mainly dealt with. Sure, the employer's providing a mask, but they're only providing me with one mask for my 12-hour shift. They should be providing me with more masks so I can change them out every few hours. So those are some of the concerns that we had to talk through. And then also how these safety protocols affected other areas and other working conditions. For example, for our warehouse workers, they work under production standards for some of our bargaining agreements. And these standards are calculated by very specific algorithms that factor in time for going to pick a proper order, going and taking that order to a certain aisle. Everything's calculated. So whereas before, it might have taken 15 to 16 minutes to complete a task, now, because they're wearing masks in a warehouse that isn't, doesn't have the best ventilation in the middle of the summer, and now that they're being forced to social distance, so they have to wait for coworker Joe to move from that area before they can access it, and now that they have to take frequent breaks for sanitizing, the same job that took them 15 to 16 minutes now takes 17 to 19 minutes, and some of them were being disciplined because of that. So those were some of the grievances that we saw as a result of safety protocols, which again required us to, speak with the employer and discuss temporary provisions that would relax those production standards so that individuals would not receive discipline. But then going back to your second question, Rick, I think that was what helped us through this process, was just, again, the collaborative effort between the company and the union of what works, what doesn't work. We negotiated a policy together. Now we're seeing that policy is affecting other areas. So having the ability to continue to revise policies and allow them to evolve as we learn together, because we're working in the dark together through this new pandemic. And I think that was something that was a big takeaway for our local, just seeing how much more we accomplish by, working together, and seeing that now that we have negotiated several policies, now in the future, we have several mechanisms in place to reference should something like this happen again.
Yeah. And I'll take it, Mycah, as she should, is really taking it from kind of what I would say the employee to management, or the employee to the employer relationship. And I still have nightmares over this. I'll take it from the government regulator to management to employee side of things, where, when this happened, and as we move through this, employers were really faced with a slew of potential regulatory issues and hurdles here, from the general duty clause under OSHA and what are we supposed to do to maintain a safe workplace, how does that work, to OSHA rulemakings, to the CDC issuing all sorts of guidance about what we were supposed to do and and I saw a question there about requiring employees to show up at a hospital to take COVID tests. I don't know what the source of that was, but there was a time where employers were looking at rules that they had to keep track of, the vaxxer test statistics, and how are we going to do that? And so, kind of from the government side to management, there was a lot of chaos in terms of what were the safety protocols, what did they need to be, who were the regulatory agencies that were going to impose these things on us, and what were they going to impose, and how are they going to impose them, and what were the record keeping requirements, and all sorts of things that companies were trying to sort through on the one hand. And then on the other hand, you have the employees, talking very properly about, you guys haven't provided us enough hand sanitizing stations. You haven't provided us enough masks. We've got to do this in this area with these folks. How are we going to kind of, just as a practical matter, work through this process of social distancing in a warehouse? And so there was a lot going on with management, really very much stuck in the middle of this and trying to jump in 5 different directions and satisfy 4 or 5 different regulators, while keeping its employees safe and productive and coming to work in very difficult situations. And so I agree with Mycah that it created a lot of opportunity for collaborative effort, where sometimes there had previously been maybe tension or kind of fist headbutting back and forth. But the other thing that I will say is that Local 988, it was very collaborative in that process, and it's unfortunate that there are other unions out there that were not as collaborative. And it wasn't a conversation with them. It was a grievance. It was pushing to arbitration. It was, those sorts of things rather than trying to work through it. And so, I'm glad that we're past it now, certainly. And I'm also glad that, we were able to build some relationships, some additional collaborative relationships with unions through this process, such that, it's not a zero-sum game. And I think both parties understand that a little better as a result of this.
Plenty of discipline cases came out of COVID-related safety issues. As you can all imagine, a lot of them are fairly amusing because there's no end of the ways that people will treat each other badly in the workplace or do stupid stuff in the workplace. So an employee at a hospital who threw a big pizza party early in COVID when people were not supposed to be eating together or everyone was supposed to be socially distancing. A school gardener who flagged the van driver over, deliberately coughed on him several times, told him that he was going to be a science experiment because he'd just come back from having had COVID, and coughed on him a few more times on purpose. Not surprisingly, these folks got disciplined. Lots of good stories to tell, but we're going to be running short on time, so I'm going to keep moving ahead. Sick pay is an issue that keeps coming up, and I'm still seeing it now with folks, because we still sometimes have to quarantine, and the problem again is that the provisions in collective bargaining agreements weren't necessarily written with COVID in mind or with quarantining in mind, and so if I'm asymptomatic, I haven't tested positive, but I have been exposed and I have to quarantine, or I've traveled and I have to quarantine. Am I entitled to sick pay? I mean, I'm not sick, but I have to stay home for a reason that's very closely related to being sick or that prevents other people from getting sick. Should I be, can I be required to use my sick time during that? Lots turns on contract language, but again, the contracts obviously often were not drafted with this in mind. Any thoughts on that, or should we move on?
I'll jump in real quick on that. I know we're running short on time, but where a lot of my clients wound up on that was, they just kind of followed the motto of do the right thing. And so, most of them wound up either allowing employees to take vacation or use their sick time to receive pay during that time, or granted some period of pay in addition to sick pay and vacation for that. To the extent that there were union relationships, obviously the union representatives were very much interested in keeping money in those folks' pockets, and so that one kind of worked out, I think, on a case by case basis in my experience. Again, the problem was stopping it.
And then, of course, during that time, the Families First legislation that came out, that was very helpful as a guide, and something that was required to those who fell within the act. But the huge exception applied to the majority of our groups, because it did not require employers with more than 500 employees nationwide to provide paid sick leave. So, we had some employers that were willing to work with us and develop a temporary sick leave policy that mirrored the Families First Act, which was great. And we had some that only offered to provide paid sick leave to employees if they were exposed at work and the employer required them to isolate or quarantine. And then we had everything in between. But the one thing that I saw throughout a lot of these policies is when an employee chose to quarantine, that employers were vocal that they have the option to use any sick time, vacation time, but they made it the employee's choice.
Mhm.
So I want to shift now to the vaccination cases and especially the employer requirements of vaccinations. And here we're going to talk about duty to bargain, both over the vaccine mandate itself and over the effects of the mandate. Does the employer have to provide alternatives such as testing or isolation in the workplace? If the employer does provide testing, who pays for it? And can the employer exclude non-vaccinated folks from places in the workplace? And finally, discipline. Can the employer discipline employees? What should that discipline look like for not getting vaccinated? And the first issue I want to throw out is one that's been a very hot one in Canada, a little bit less so in the US, and that is medical privacy issues. In Canada, it's a big deal because there is a statute that provides medical privacy much more robust than what we have in the US. And in Canada, arbitrators are given the power to pass on statutory issues. And so privacy is one of those. In the US, it's different. Obviously, HIPAA doesn't apply, but nonetheless, medical privacy issues still come up a lot, especially in the mandatory vaccine context. And so I want to ask Mycah and John to comment on that. And while you guys comment, my dogs are going absolutely crazy. If you guys will talk for about 2 minutes while I go find out what my dogs are going crazy about, make sure that they're not tearing up the other room. I will be back in 30 seconds.
That once again, one of the joys of COVID is dogs going crazy while doing things from home, and you're on mute. I didn't really have a lot of concern. I mean, we had medical privacy issues that arose, but my clients, generally speaking, are pretty familiar with the medical privacy issues from the employer side of things. And so we didn't have too many issues on this. The only time that it really came up on the employer side was when we were talking about, the potential OSHA requirements, the vaccinator test, and how are we going to maintain those records, and what are we going to do with those records, and those sorts of things. But given the way HIPAA works, there was some gnashing of teeth over that. But at the end of the day, it didn't really, I don't think, turn out to be a huge issue from my perspective. And I don't know, Mycah, what you think.
Yeah, not so much with vaccine reporting, more so actually with the daily health screening that started to be used earlier in the pandemic, of submitting your temperature and answering a set of questions. And of course, the EEOC issued guidance for that led us through that and helped dispel some misconception to employees. But as far as vaccine reporting, we didn't have any privacy issues. We did submit some information requests to employers, just asking that they explain to us how they would record keep any of those reports and safeguard that information.
I see in the comments that a couple people commented on that, on the vaccine issue. Jeanette Fidel says that inadvertent release of employee private health information was a huge concern among her union clients and union members. I thought I had seen, and she'd also added earlier that after the family's first legislation expired, employers of some of her union clients continued to pay for some time off due to exposure quarantine, but only for those who were vaccinated. I know I kept saying as an arbitrator, one of the biggest problems seemed to be just the flow charts and how people were supposed to know when they were supposed to go into quarantine, or just sheltering in place, and what was the difference. And it seemed like the more legalistic and contentious the relationship was, the more likely there was going to be layers of sometimes contradictory flow charts, and that it looked like it was just kind of kicked to the employee to figure out where they fell on this flow chart. And sometimes you'd have 2 or 3 that were put together, they were pretty complicated. Did y'all run into issues with that sort of stuff?
I
John
think
and Mike?
we saw some issues with the frequency of changes to CDC guidelines. And as often as that changed that first year, policies weren't always revised right away. So, we'd have an employee file a grievance and say, well, they're saying that I have to stay home for 14 days, but the CDC says I can come back after 10, and just, different timelines that we had to keep reevaluating and revising. That was a bit confusing to keep up with for employees as well as for employers.
Yeah.
And I would echo that. I mean, the changing guidance in terms of what employers were allowed to do, what they had to do, I'm sure created confusion on the employer side, and some lack of consistency in terms of how those policies were rolled out and applied, even within a medium-sized organization. Number one. And number two, as employers got better at this in terms of how are we going to get folks in the door, how are we going to separate folks, how are we going to get folks out at the end of the day, as those procedures changed, sometimes the communication around that was not the best, and it created some strife for sure.
So duty to bargain and over vaccine mandates. Is there a duty to bargain over the vaccine, a vaccine requirement itself? And even if not, is there a duty to bargain over the effects? Most arbitrators have found, and most of these cases so far have been Canadian, but most arbitrators have found that there is not a duty to bargain over a requirement that the employer, or over the requirement that employees get vaccinated. So an employer can impose that unilaterally without bargaining. And they found that on the grounds that I mentioned here: management right, consistent with the employer provide a safe workplace, consistent with the employer's contractual right to implement reasonable work rules. Far more arbitrators have found that there is a duty to bargain over the effects of a vaccine mandate. So deadlines, reporting requirements, how do you report, how often do you report, and exceptions. And I want to talk more about the exceptions a bit later on when we get to discipline. Always struck me as, if the parties have a good working relationship, I think if I'm the employer, I want the union at the table when we're trying to figure out how to, whether we're going to have a vaccine mandate, what it's going to look like, what the exceptions are going to look like. But again, that probably presupposes a good working relationship. John, Mycah, do you have some experience dealing with this?
Yep. So 100% on a lot of it depends on the nature of the relationship between the company and the union. Historically, has the union been a partner in helping to solve problems and trying to bring employees along to where the parties need to be? Of course, representing the employee's best interest, but working together collaboratively to try and solve a problem. Or has the union historically been a little bit obstructionist, and if the company wants to do it, they say no, which really, I think, drove a lot of decision making potentially up front, along with the need to move quickly or not move quickly with respect to these issues. And so, I generally agree that the implementation of a vaccine requirement or a vaccinate and test requirement, is an inherent management right under most agreements, if not all agreements. From an NLRB standpoint, I'm sure there could be some questions and debate about that for 8A5 purposes. And I think there's probably some question and debate for 8A5 purposes about effects bargaining, especially under the current state of the law, whether a contract actually covers something, and hence there is no effects bargaining requirement, as the 7th Circuit might say, or the DC Circuit might say, or, despite the contract covering something, there still is a duty to bargain over the effects. But again, if what we have is a governmental mandate, or what we have is a duty to maintain a safe workplace, I believe the employer has a fair amount of discretion to act there, subject to, this is how we're going to roll it out. These are going to be the impacts of it, those effects discussions, which I consistently advise my clients to talk with, their bargaining representatives about.
And from my perspective, the only industry that actually mandated vaccines was a subcontractor on a federal government contract. So as there's legislation that covers federal government employees being vaccinated. That kind of led us there. However, we did bargain over the effects. And something that I wanted to add to this slide is pay, as far as who's going to, or how is the actual time being spent to go get vaccinated? Is it paid? Is it done on your own time? And then also, what if you have an adverse reaction and you need to take the following day off because your employer required you to get vaccinated and you just had a bad reaction? So those are some of the concerns and issues that we discussed.
Yeah, and actually, the only industry that I had that, from a union perspective, that wanted a vaccine mandate were teachers. I had one union that represented, some elementary and preschool teachers, and they came to us and said, "We want you to implement a vaccine mandate." So there you have it.
Yeah, we saw a lot more incentive-based programs to encourage vaccination more than anything.
Or vaccinate and test. Vaccinate or test. Yep.
And let me use this as an excuse, Mycah, to ask you a broader question, which is vaccine mandates, I think, often have put unions in a tough position because unions represent a very diverse constituency. You've got some folks who, perhaps for medical reasons or ethical reasons or truly believe in vaccines, and then you've got some who don't and are very vocal about that. How do you balance that?
You stay out of it. I'm just kidding. That was something that we dealt with. And I think instead of bringing in either, your personal concerns, your political party priorities, what we're here to do ultimately is represent the best interests of workers and ensure that their health and safety is a priority with their employers. So anything that we would negotiate with employers regarding any vaccine mandates or effects bargaining resulting from that would, of course, want to build in some type of alternative to being vaccinated. And so, at our local in general, we try to steer away from, either being on the left side or the right side or taking a hard stance on one or the other, because we do have a duty to represent all of the bargaining unit members. So we just try and make sure our focus and priority stays on the overall health and safety. For some, that's going to be through being vaccinated. For others, to preserve their own beliefs and whatnot, that's going to be, weekly testing should it be mandated.
Mycah, you just gave me a great opportunity to transition to the next series of slides. I'm going to go through a couple of slides here real quick before I turn it over to both you and John. And you talked about negotiating for alternatives to the vaccine. So either I get vaccinated or something else. And one of the possible alternatives is testing, right? So either I get vaccinated and prove that I'm vaccinated, or I agree to submit to weekly COVID testing. One of the issues that's come up is an employer required to offer that testing? Now, again, obviously, if you're bargaining, you can bargain for that alternative, but given that most arbitrators have found that there is either a management right or a duty to provide a sort of safe workplace, justification for the employer to adopt a mandatory vaccination policy unilaterally, if the employer adopts it unilaterally, must it also include a testing option? One Canadian arbitrator has said, yes, there must be a testing option, but every other arbitrator has distinguished that case on its own facts and has more or less said that, at least generally speaking, a testing option is not required. It's not a required component of a vaccine requirement. imposed by an employer. And the employer is most likely to get that kind of a ruling if the employer has shown that, hey, we had testing in the past, but still our employees got infected, or most of our work is done indoors in close quarters, or third parties, say our customers, or we have to go on site to other places, and those third parties either require or strongly encourage vaccinations. If you have let me skip ahead real quick, and then I'll come back real quick. If the employer does provide testing or does have a testing alternative, who pays for it? And a second alternative, so one alternative to vaccination is testing. A second alternative is isolation. Can you put me in a spot of the workplace where I'm not going to if I'm not vaccinated, where I'm not going to come into contact with others? One Canadian union proposed that, okay, the employer has 2 work sites. Let's make one work site for vaccinated employees and another work site for unvaccinated employees. Employer opposed that one, and the arbitrator didn't require it. But let me throw it back to you. Must there be alternatives to testing? And if so, what might those look like?
I guess Rick, and I'll start on this one. I think where most of my clients wound up was a vaccinate or test regime. It was very rare that we had someone that mandated vaccines alone, for the reasons that we've already discussed, right? There are potentially a slew of exceptions to that requirement anyway. There could be religious exceptions, there could be medical exceptions, number one. And number two, the end of the day, employers need employees to work. And if they impose a rigorous vaccine mandate and employees say, I'm not doing it, and go someplace else, that's not terribly helpful. Most of my clients wound up in a vaccinate or test situation. We did not wind up in a vaccinate or test or do something else situation. There are a lot of restrictions with a lot of companies about, not all companies have 2 work sites. Not all companies have the ability to try and isolate someone at some part of the office away from other people. And so, if you get down that rabbit hole of, we can do these 12 different things, you're going to be doing 12 different things for 12 different people, and it becomes really unwieldy. And so, that's where most of my clients wound up.
And as far as required alternatives, and on this slide, isolation, I'm just, imagining work locations that do not have multiple work sites. So even as far as a break room, if the employer were to segregate the break room or impose a separate break room for vaccinated versus unvaccinated, that has the potential to lead to a hostile work environment. With individuals that feel so strongly about those that should be vaccinated or vice versa. So that would be a big concern from the union's perspective. And while the employer is, safeguarding the actual documentation and not disclosing it, it is indirectly being disclosed by separating these work areas between the 2 groups. So those would be big concerns. And I have a question. I don't know if John or Rick, you could answer this, but for those situations where the employer mandated a vaccine, but offered the alternative to test at the point where home tests became readily available, was that acceptable?
So again, I don't know that I really had a situation where an employer mandated. The debates that we got into were the debates that Rick mentioned, which is who pays. And, a lot of my clients and, my personal opinion is that we got to a point in the US where vaccines were readily available. They were free. They were generally pretty easy to get. And, that's the way to best safeguard yourself. And if you make a choice not to do that, that's your choice, but you're going to have to go do the testing, which also, by the way, became readily available and, generally free. You're going to have to do that on your own time as part of that's part of a job requirement, like getting in your car and driving to work.
So final, or pretty close to the final topic anyway, is discipline. So employer has either a vaccine mandate or a get vaccinated or get tested requirement, employee doesn't comply, what happens then? Only a handful, I mean, a very, very small number of cases have actually gone to arbitration on this issue. I suspect that many, many more are in the pipeline and just haven't gotten to an arbitration award yet. One case and other cases have cited, or one award and other awards have cited to it, has said that the employer's policy itself cannot have a flat get vaccinated or you are fired requirement. That there has to be, most contracts have just cause provision. And so the contract should say something like, get vaccinated, and if you don't, then discipline up to and including discharge will be the result. But there has to be some sort of an end out for an employee to show individual mitigating circumstances and to make a just cause argument. Again, only a very small handful of cases have actually gone to an award. Most of those have, or in fact, all of them have upheld discharge for an employee who refuses to comply with the vaccination requirement or the vaccine or test requirement. If you look over in the right-hand column, I think that this is probably where most of the awards are going to go when more of them come out, which is that, look, either being vaccinated or submitting to regular testing, that's now a job requirement. And if you don't get vaccinated and you don't submit to testing, then you're just not qualified for the job. But again, very, very few cases have come up on this. And I'll show the final slide and then open it up for final discussion, which is, John, you alluded to this just a minute ago. There are lots of exceptions. One of the big ones is religious exemption. At the National Academy of Arbitrators convention about a week and a half ago in Toronto, this is what's on everyone's mind. We see this coming, right? Employer requires vaccination or vaccinate or get tested. Employee says, I ain't gonna. I got a religious exemption. Employer has reasons to doubt the good faith of that religious exemption claim. Fires employee, goes to arbitration. Arbitrators do not want to be in the position of having to evaluate whether a religious claim is good faith or bad faith. And my guess, John and Mycah, is that you guys probably don't want to be in that position either. What do you think? Where are we going with these cases?
Yeah, certainly the employer does not want to be in the position of, trying to take a guess as to whether a certain religious exemption is a bona fide religious exemption or not. I know these issues are coming up. I know when these policies were rolling out, there continues to be big debates about, when is it a bona fide religious exemption? There is case law under Title VII, and the religious discrimination cases and religious accommodation cases that is analogous, but it very quickly becomes a morass that I don't think employers really want to be involved in. And so that was also a driver towards vaccinate or test for a lot of employers.
Yeah, and from our perspective, what kind of proof would an employee be able to provide to an employer to show? So to me, that just sounds like a difficult road to go down. Now, in situations where the employer has some objective reason for believing that the individual is not a part of the alleged religious organization. Say, for example, if he's overheard saying he just doesn't want to get vaccinated and he's going to, tell the employer that, is against his faith and his practices, then that would take us into that situation. But again, how are you going to prove, or how are you going to require that he prove that he's either in that religious organization or not? So I can't lend any specific examples from my practice to that, but those would be areas that I would be a bit concerned with.
I want to point out that Carl Boslin, arbitrator Boslin, pointed out that we also see ADA Rehabilitation Act, reasonable accommodation exceptions. And it's right up there with religious as far as tricky and fraught. What have y'all's experiences, if you've had any, been with ADA or Rehab Act exceptions?
Really it's the same, right? Again, driving away from a strict vaccine mandate to, a vaccinate or test type situation where testing generally, in my experience, has not run afoul of any sort of disability type issues. But, under the ADA, you've got the interactive process. And, if the preference is vaccinate and the employee says, well, I'm not going to vaccinate because I have a medical condition that prevents me from doing it, then you have to have a conversation about, how can we allow you to perform the essential functions of your job and maintain the safety of our workplace. So, for me, that's just a very practical, we're going to comply, just like you take with the workers' comp, FMLA, the ADA, they call that the triangle, and you take each requirement and you apply it and you see where you wind up. I mean, I think we're kind of in the same situation here.
Emily Hall, she's a fairly new arbitrator. She's from Alaska. She writes, no religious exemptions, she believes, were given to military personnel who wanted them. They've gotten every other vaccine required. I was in the military. My brother's in the military. We all remember standing in line and getting repeated shots. I did notice that I heard recently that every branch essentially granted no exemptions. And there's a case with I think Air Force Academy where 3 people were not allowed. They were allowed to graduate, but they may have to pay back. They couldn't walk. They don't become officers, and they may have to repay their scholarships back, which is pretty intense. I wanted to ask real quick, because I know we're coming up to the end. Do any of y'all see it significantly different treatment or handling or analysis, whether it's private sector versus public sector, if you deal in both sectors as either advocate or arbitrator? Throwing it to all of you.
I haven't seen a significant difference.
Okay.
Yep. I think from a bargaining standpoint, if in public sector, you're in a situation where you're in a statutory bargaining relationship pursuant to state law, kind of the obligations are the same in terms of dealing with each other. The overlay that I think I have run into is what are the bargaining duties from a statutory standpoint, right? Or if you're under the National Labor Relations Act, you may have something a little different than what you would have under a state law bargaining statute. From a regulatory statutory situation. But if you're in a contractual relationship and your contract says X, I think you're probably in the same situation.
Okay, thank you.
John, Mycah, do you have any final thoughts? Are there any COVID related topics that we haven't talked about that you'd like to?
Nothing from me. I want to thank everyone for the opportunity to chat and to participate. And I think we've covered everything from my perspective.
Yeah, same here. I mean, it's been nice reliving what was so terrifying back in 2020. But as we were talking the other day amongst ourselves, Rick and John, and I'm sure the rest of the individuals on here would agree. I mean, 2020 was 2 years ago. But it just seems like we never came out of that year. So looking back right at this point, as we're going back through these, it was just a very surreal process and ever changing. And, there's always a new wave around the corner, a new strand, a new disease like monkeypox. I mean, something's always out there. So I think, again, having this mechanism in place of what worked and what didn't, will help us continue to work together and enhance our partnerships between labor and management.
It's a great line to close out on, Mycah. Thank you so much. Sherry, were you going to wrap things up?
Yeah, I was. First, Richard, Pilar, Mycah, John, you guys were just so awesome. And, thank you so much, Bernadette, you and Emily up at LERA National for hosting this. I want to let everyone know that right now there are plans underway with the youth and LERA to do another program in September and in November. And then currently, and hopefully nothing will change that, there will be an in-person holiday celebration in December. So, thank you, everyone. I think, Nikki, did you have anything you wanted to add it on the announcements?
Yes, I wanted to just make one comment, well, two comments. First, what a fantastic panel. Great job. And I'd just like to offer special thanks to Sherry, who took the lead in pulling this program together, and great job. So thank you. And thanks to everyone for participating.
Bye, everyone.
Bye, everyone.
In September.
Now.
See you in